hosting tonight's session. Lori and I are glad to be back to talk about this time in session 2, creating an inclusive culture for employee retention. Albert Einstein once said, and I quote, "Everything in your life does so because of 2 things, something you did do or something you didn't do." What Lori and I will present this evening has much to do with Einstein's wisdom here. In business, we all know the consequences of what we do versus what we don't do or didn't do directly affects people and outcomes. So our theme this evening is about choice and attention versus the risks of chance that come from doing nothing. But before we get into today's topics, let's take a look at the key takeaways from our first session last Tuesday. And by the way, the replay is available at the link you can see here. And if you're not into doing print screen and copying it, you can go to the website that John mentioned, and it's also available there as well. But last week, we talked about actions any business can and should do to increase employee retention and reduce turnover from both an operational and a legal point of view. I started by talking about the importance of connecting the whys of the business to employees, especially when it comes to talking about values, mission, and vision, and to do that frequently and consistently. To practice what I call the 13X rule, to dramatically increase dialogue with employees and to listen more than talking. To answer 5 questions employees are always asking that had everything to do with getting them connected to the organization, the hows and the whys. How should I do my job? What should I do? How am I doing at it? Why should I do it? And what's my future with the organization? Lori then talked about the importance of getting up to speed with required benefits from a legal and technical point of view. She talked about the importance of reviewing and updating your employee handbook on a regular basis to ensure compliance with regulations and laws and to show the flexibility the organization has with employees. And then Lori also talked about elements of non-compete agreements, especially considerations you want to take into account on a pre-hire basis. So tonight, though, I'm going to begin by focusing on the impact that culture has on creating an inclusive work environment. Specifically, we're going to look at the differences between intentional culture and one that just happens, key culture influences that you must not ignore, the crucial role that leaders have in determining culture, and signs of an ideal culture you can use to evaluate your own company or business. Lori's going to then talk about more legal technical practices you must successfully navigate to ensure an inclusive workplace, including compliance with discrimination and harassment law, disability protection, and what comprises reasonable accommodations to provide to employees. And she's also going to share an HR employer to-do list that you can use, again, for your business. We'll then conclude by giving you access to free checklists and resources. So let's get started here. Every organization, every business has a culture. The question, though, is this: is it a culture that grew out of chance, or is the culture intentional and based on good choices? A culture by chance leads to random consequences that can hurt. It simply invites trouble. I like comparing a culture by chance to the equivalent of giving whiskey and the car keys to teenagers. And we all know, if we think about that for a second, what bad things can go wrong when that occurs. Also important is that if you ignore culture, it will tend to undercut performance because of the unintended consequences that will arise. On the other hand, intention and choice reinforce desired outcomes. The right culture reinforces the proper flow of the business by positively impacting employee engagement, customer loyalty, growth, and employees who will stay rather than leave. To better understand culture, though, it's helpful to view the key factors that determine or influence it. And these influences interact with one another to define the culture of any business. But first, we have to pause and recognize that every business has a formal and informal part. And I'm going to go through some examples of informal and formal and informal, or tangible and intangible influencers that help comprise or define what culture is, or that things that influence a culture in an organization. They have to do with how people act, how they feel about work, how they process knowledge and meaning, and how they connect. Just a couple of comments here in terms of what I mean by all of these. How people act in an organization and its impact on culture On the formal side is decided or is influenced by the decisions or the decision processes and authorities that are granted within an organization. Who has the authority to make decisions? Who has the authority to act? On the informal side, how people act is determined by norms that have to do with how people instinctively act or make decisions in an organizational or a personal environment. In terms of how people feel about work, motivators on the formal side are very important. And motivators have to do with the compensation plan, career paths, incentives, and recognition. On the informal side, it's the level of commitments that people have that are determined by how they're inspired to contribute. How people process knowledge and meaning on the formal side has to do with how data and information is shared within the organization and across people. And on the informal side, how people process knowledge and meaning has to do with their mindsets, how they make sense of their work. And lastly, how they connect to the organization on the formal side has to do with the organizational structure, processes, and the formal relationships and sense of and how work and responsibilities get divided among people. On the informal side, it's the networks that arise quite informally quite often. It's the things that connect people beyond the boxes and lines on the org chart. For instance, how teams form, how people collaborate individually or together. So this is a bit, admittedly, a little bit of a busy slide, but it does give you a sense of, in total, the culture influences that go together to influence culture in an organization. If you are a leader, please don't be one of these guys. Leaders and managers have a huge impact on a company's culture. To achieve a culture by choice, there's no getting around the actions of leaders, what they pay attention to, and the behaviors that they reinforce or that they don't. Their attitude and behavior must set an example by demonstrating a personal commitment to company values, mission, and vision, promoting dialogue and new ways of communicating, being sensitive to the needs of employees and customers, and always encouraging new ideas. It's also important to understand what they pay attention to. For those of you who might have attended last week, I talk about the 2 truths of human behavior that you can turn into an ally in an organization. And those 2 truths are these: what gets talked about and what gets measured in this world is what gets done. So what gets talked about by a leader and what they measure will tell the organization what they pay attention to, and what they pay attention to is what people in the culture will pay attention to. Similarly, what leaders reward in terms of behavior and what gets punished also has a direct impact on culture. And finally, how the leaders allocate their attention and the resources of the organization will also help define culture and what's important. So think about it for a minute. If you given these behaviors, and it's no surprise that according to Gallup research, leaders account for most of the variation in employee engagement scores from one company to the next. Here are 6 key signs of an ideal culture. Now, these are nearly impossible to achieve in a culture by chance. So it's important to choose to make these as goals in a culture by choice. And as you read these, note how transparency, communication, and ethical behavior are underlying themes here. You see, achieving the right culture requires intention and actions that are sincere. And if leaders are not willing to do so, neither will anyone else. So it's important to note here, there are 6 particular signs of an ideal culture here. Hopefully most of these are relatively obvious. And I want to transition to Lori, especially that one on the bottom. It says ethical hiring and workplace practices. And speaking of those kinds of things, I'm going to go to Lori now to get into some specifics. So Lori, I'll let you take it from here.
Thank you, Mark. That was, I'm very happy to be back. Nice to see some of the same people that are here from last week. And I'm learning so much from you, Mark. So, you know, I love to co-present because part of the benefit to me is I'm learning from another professional who's not necessarily a lawyer. And there's so many perspectives here, but they really connect. I mean, you know, I keep nodding my head because, you know, so much of it makes sense. It's, you know, and hopefully you don't need a lawyer to tell you to do some of the things that Mark is telling you, because it should be common sense. But one of the most important elements of attracting employees and keeping employees is to have an open, welcoming, and inclusive environment, and a culture like that. And Mark's advice is common sense practices: treat people with dignity, be honest, be intentional, give regular feedback, let people know, positive and negative, how they're doing. Give them their expectations so they know what's expected. It's not a secret. You can provide constructive criticism, and I know many managers don't like to do that. They only like to give the positive, and incentives, and you have to be able to have the hard conversations also, because the idea is that it will hopefully ring a bell and cause improvement, which is what the goal is, and give people opportunities to improve. So everybody's human. Sometimes people disagree. We may not all be friends with the people we work with. There are definitely different management styles, but two-way communications are important. And I just learned today that the new CEO of Starbucks, who just replaced the one that I guess retired 2 weeks early, he's taken 40 hours of barista training, and he said that one day every week he's going to work in one of the stores and talk with the employees and be there and listen. And I thought to myself, not only is that going to avoid or reduce the possibility of unions, because, but this is two-way communication. He's there, he's engaged, he's not, he's the top of the company, but he's going to talk to everyone there and listen anyway. So some of the things that Mark says, to do and not to do, some of the things not to do, and these again are common sense. Don't fire somebody by text or email. Don't do it in front of other people and humiliate the person that you're letting go. Be respectful when you let somebody go, subject to obviously exceptions for serious misconduct or situations like that. But if you treat somebody like a human being, when you let them go, they'll leave in a better state of mind. They'll have a better opinion of your company and the management. Hopefully they won't run out and start bad mouthing the company, which will make it easier for you to keep and attract employees. They will also be less likely to run to a lawyer to try and challenge this termination. And sometimes consider giving them severance in exchange for a signed release, just to get peace of mind, even if it's a totally lawful termination. So besides the practical, let's get to some of the legal requirements. The obvious ones for culture are that you should not be discriminating, harassing, or retaliating against employees for making complaints about discrimination or harassment. So let's start with the legal definitions of these three words. Discrimination is basically treating somebody differently, giving them unequal treatment because of a legally protected characteristic. And I've listed some of the typical ones here: age, race, national origin, disability. It means, in non-legalese, treating somebody differently than a coworker who is, again, in legalese, similarly situated, which isn't always easy to show. But you might be getting you might be treated differently than somebody that works in North Carolina because perhaps their cost of living is different, or they do different benefits there. So you have to be able to compare yourself with somebody in a similar role or similar situation, but isn't in one of those protected categories, and they're being treated better. So if it's based on a legally protected category and it's differential treatment, that is illegal. Not all discrimination is illegal. For example, if the boss gives more favorable treatment to one of the employees because the employee happens to be the boss's daughter, maybe the boss gives the daughter a promotion even though somebody's been there longer and thinks they deserve it. There's no protected category of being a child of the boss or not. So it might be unfair, and you might decide you're not going to stay at that company, but it's not illegal because it's not based on a protected category. But from the big picture perspective of attracting and retaining employees and the ideas that Mark brought up, even if it may not be a risk or a liability, do you really want to be a company that treats people unfairly or unprofessionally? While it might be lawful to fire somebody because they're at will and you're not doing it based on a protected reason or retaliating against them, would you really just do that for no reason at all, without any notice, without some kind of ongoing feedback? Again, assuming there hasn't been some serious misconduct, to give them a heads up so they're not surprised. And so you've done what you can to try and prevent the termination. So back to the law. The categories protected from discrimination and harassment depend on the law that applies. And on the next slide, we'll see the different laws, but there are federal, state, local laws. They have different types of protected categories. So harassment is also based on a protected category, but it consists of unwelcome. So it always has to be unwelcome conduct that's either verbal, physical, or visual, that's based on a person's protected status and creates what we call an intimidating, hostile, or an offensive work environment, which basically means it's unreasonably interfering with your ability to work. It's affecting somebody's job opportunities. And when we talk about unwelcome, which is not always easy to know from either side, the law focuses on the victim, not the perpetrator. So even if you don't intend to offend somebody by saying something or asking a question or engaging in some kind of conduct, but they reasonably perceive it as offensive, then it's harassment. So that makes it difficult these days. That's why lots of people say to me, we can't say anything at work anymore, and we don't know what to ask, and we can't compliment anybody. So everybody just comes to work and goes into their office and we don't talk. It doesn't have to be that bad, but there's a lot of gray areas. So hostile environment, and I get lots of calls like this. My boss is mean, he yells, he slams the door, he's swearing at people. He's that kind of a person. It's a hostile environment. And I agree, that's hostile. It's hostile in the English sense. It's mean. It's not a healthy situation. It's certainly not something that Mark would condone for his clients, even if it's legal. If it's not based on a protected category, then it's what I call equal opportunity harassment, and it's not illegal. It doesn't make it right. But again, so hostile doesn't mean I have a mean boss and this is the way he is with everybody. But if he's picking on older people or women or people of a certain color, then you might have a problem. And then that may be illegal harassment. So retaliation then is when you have an adverse action taken against an employee at work, demotion or discipline, giving them inaccurate information to kind of set them up to fail, exclude them from meetings and things. Retaliation based on somebody making a good faith complaint or asking questions about a possible legal violation. So somebody who complains that they're being harassed because of their gender or their race, or they're not getting disability accommodations, which we'll get into later. If there's retaliation for that, that could be illegal. But if you complain that the boss made her daughter the VP and not me, you're complaining about something that's unfair, but not illegal. So if they fire you because you complained about it, it's not illegal. It's not fair. And again, would you want to stay at a place like that anyway? So those are the differences between the three. Next slide, Mark, please. So these are the laws that apply to discrimination, harassment, and retaliation in the workplace. So we have, as I said, federal, state, local laws. Title VII of the Civil Rights Act of 1964 has been around for a long time. It started basically to protect against race discrimination in the 60s. There's now a long list of protected categories. It includes gender, it includes sexual orientation, and national origin and religion, sexual harassment. But it applies to employers that have at least 15 employees. So there's a lot of smaller companies that aren't covered by this. Similarly, the Federal Americans with Disabilities Act, the ADA, covers the same size of employer, 15 or more employees. And it's similar to Title VII, but it's focused on disability. So no disability discrimination, no harassment, and it requires employers to provide reasonable accommodations for people with disabilities, which we'll get into later. The Age Discrimination in Employment Act covers employers with 20 or more employees. And if you are age 40 or older, you are protected by age discrimination laws. That's the law that's federally and Illinois and most of the states, I believe. We don't have any mandatory retirement, except in a couple of industries. Unlike France now does not have mandatory retirement, but you may have heard that the president just raised their retirement age from 62 to 64. So people can't, I guess, get retirement benefits until then. And there's a lot of noise and protests going on there. If you were to file a claim under one of these statutes, you would go to the Equal Employment Opportunity Commission, which is a federal agency, and you have 300 days to file a claim, basically 300 days from when the first incident of discrimination or harassment or retaliation occurred. So you can't wait for years. If you're not covered by, well, some companies are covered by those statutes as well as the Illinois Human Rights Act. But as long as you're a company that has one employee in Illinois, even if your company's in North Carolina, you're covered by the Illinois Human Rights Act with respect to that employee. And it covers all of the categories that I talked about, including disability and age and the things covered by Title VII. Something that changed a couple of years ago is that the Illinois Human Rights Act now covers independent contractors as well. And just today, I got a call from a client, an employer with a contractor who's asking for a reasonable accommodation for disability. I've never had this occur, but they have the right to do that. So be careful now that, contractors aren't entitled to a lot of employee benefits and rights. This is one they are entitled to. And then if you're in Cook County or Chicago, they have their local human rights ordinances that are very similar to this. And if somebody were to win one of these claims, they could get reinstatement back to the job if they were fired or, had to leave. Back pay, sometimes you can get front pay, which is a year or two beyond, the date that the lost pay that you received for the past. You get your lost benefits. You'll also get attorney's fees reimbursed, and you can get punitive damages and emotional distress damages. So it can be very costly to a company. Any questions at this point? Doesn't look like we have any. Okay, Mark, next slide.
No questions right now, Lori.
Okay, thank you. So discrimination and harassment laws also protect people with disabilities. And of course, we have laws and legalese that define what disability is. So a disability under these laws is an impairment that substantially limits one or more major life activity, or a history of having such an impairment. So even if you no longer have that disability, or even being perceived as having such an impairment. So you could be misperceived as having a disability. You're still protected by the disability law. This could include an episodic impairment. So somebody that might be in remission and doesn't have any current symptoms, but from time to time does, which could occur with other things like migraines. It applies to all terms and benefits of employment, everything from the pre-offer stage all the way to the end of employment. Insurance, you can't make a decision because of actual or anticipated increase in insurance costs or premiums because you have an employee with disability. And by the way, disability law under federal law and Illinois prohibits discrimination based on disability association. What that means is that even if the employee is not disabled, but they have an association with somebody who is a child, a parent, a spouse, and it's affecting insurance or it's affecting their ability to come to work. You can't discriminate against them because of that association. You can't fire somebody because their insurance is increasing because they have a sick child. So that's what this is supposed to protect. In terms of providing a reasonable accommodation, employers have obligations to consider and make reasonable accommodations which would enable somebody to perform the essential functions of their job, more legalese. But sometimes an employee will ask for something that won't help them be able to perform their job. If they're asking, they're asking for an assistant to do, some of their major duties, that's changing their job. If they're asking for somebody to help with some minor things, that's something different. But an accommodation could be a part-time schedule or a leave of absence, work from home, a special chair, a computer screen. Those are reasonable accommodations. We saw a lot of requests for accommodations during COVID. Work from home. Some people were were asking for accommodations not to get the vaccine. And we know that reasonable accommodations are usually not indefinite or long-term. So employers provided a lot of those accommodations at the beginning of COVID, but after 3 or 4 months or sometimes longer, when they needed an employee back in the office, they had the right to say, you need to be back. Even if that person is still immunocompromised and we're still having, risk out there, it changed a lot for a lot of people. So that's important to know. Again, it's important to know that at the pre-hire stage, you cannot ask any disability or health-related questions or require somebody to take a medical examination before you make the job offer. Once you make a job offer, conditional on passing the background check and anything else, as long as you give the medical examination to every applicant for that position, it's lawful. You can't just require it of somebody that walks in with thick glasses or with a cane. If you're going to require a medical examination, it has to be for all applicants or none. You can ask on an application or in an interview, the fourth bullet there, and those are the exact words. Can you perform the essential functions of this position with or without reasonable accommodations? And if the individual says, I can perform them, but I need these accommodations, then you have to go through a process to find out if they're available and they would work. For current employees, medical examinations are fine as long as it's job related and it's consistent with business needs. So again, you can't require everybody that comes back from surgery or some kind of leave of absence to take a medical exam or be able to prove that they can do the job. But if you have lifting restrictions or physical restrictions and you need to know whether somebody can safely do that job, then you're entitled to ask and get the information. It's important to keep medical information on employees confidential, which means not only should they only be discussed on a need to know basis, for example, with the supervisor for that employee, who doesn't need to know what the diagnosis is, what the treatment is, any of those details. All they need to know is we're giving this person these accommodations. You need to work with them to provide them. You keep the information in a file separate from the employee's personnel file. This is somehow not known to a lot of employers, but you can't keep the medical information in the same file because the supervisor would typically have access to a personnel file to go through, personnel performance reviews and discipline. You don't want them having access to medical information. It can only hurt you because either it's going to be used or perceived as being used by the supervisor in a negative way against the employee. So don't even go there. And then I talked about association discrimination. Next slide, please. So many of you have probably heard of the Federal Family and Medical Leave Act. I think it's been around since 1993. So a long time. It's for employers that have 50 or more employees. So it's not all employers, it's not small employers. But if you have 50 or more employees within 75 miles, so even if you have 2 or 3 locations, if they happen to be close and the total combined employees are 50 or more, that's considered covered by FMLA. This is kind of related to disability accommodations, because what FMLA does is it provides for unpaid leave of absence, which would be an accommodation for an employee's personal illness, or for an employee to care for a family member that has a serious health condition. And it also provides for leave to bond with a new child. So whether it's by birth, adoption, or foster care, and it's equally applicable to both parents, mother, father, same sex, whatever it is, both parents have the right to take this leave. The employees are covered once they've been with the company at least 1 year. So it's not for new employees, and they have to have worked at least 1,250 hours during the preceding year, the year before they've asking for leave. It provides up to 12 weeks of leave. You can definitely, there are FMLA forms that the Department of Labor has on their website that you would use for the employee to fill out, for their doctor to fill out. That it's not automatic, they have to qualify. This is unpaid leave, but it's job protected. So if somebody takes an FMLA leave, you can't fire them for taking an FMLA leave. You basically have to try and keep the job open, or give them a similar position when they come back with similar compensation and benefits. There are exceptions, and one is that if you would otherwise have let this person go during the leave of absence. So this happens sometimes. There are reductions in force, group reductions that occur while some people may be on FMLA leave. And the fact that they're on FMLA leave does not protect their job. Unless they're being selected for this reduction in force because they're on FMLA, if their group is being reduced, or these were people that were going otherwise eliminated, they don't get to stay on FMLA leave. But other than that, they have job protection. And you also have to keep their health insurance going during the leave of absence. You can require the employee to pay their share of the premiums, and especially if you're not giving them any portion of this as paid leave, where you could deduct it from. So and there are policy rules that you have, and if they don't maintain and send in premiums on time, you can cancel their insurance. So parental leave is huge these days, even for companies that are smaller than 50. Many are giving this kind of leave for parental leave reasons, for illness, even for care of family members, because this kind of thing happens. People are human. It happens. And, if depending on how big or small you are, if you can afford to give some time off, you have to give it as an accommodation anyway under disability laws. So one thing to know is that the 12 weeks under FMLA are not the be all and end all. If somebody finishes their FMLA leave and a doctor says they need a couple more weeks, I always say up to 4 more weeks as an accommodation, you have to consider that, or pretty much give them another few weeks. You can't just say, this is the end of your FMLA, you're out if you don't come back. Okay, yep, it looks like we might have some questions. Let's see. What is the best way to?
Yeah, we got one here.
Okay.
Oh yeah, best way to document your work environment concerns. Basically showing that this person is not a jerk to everyone, only to women.
Right. Well, so first of all, again, I think there should be open communications, and you should be able to either talk to your boss if you can, or talk to HR, and even if it's not, even if it's equal opportunity, you know, a not nice person, I think you want HR to know that it's not a good environment. And then if you believe that, if you have a good faith reason to believe that it's targeting certain people based on a protected reason, then definitely tell that to HR. You need to make a record. Usually there's employment policies that say, that have complaint procedures, follow them, because a company can use that against you in litigation if you haven't followed them. And I'll, because there's certain laws that say that if the employer didn't know or couldn't have known about it and stopped it, how could they be liable? And you have an employee has obligations to report it. So, so tell HR, and again, use the protected category if it really is good faith and it applies. Don't just play the race card just to do it. But if you truly believe that this is, you know, targeting certain people, then you should be honest about it. Okay, how often should we update our employee manual? Does having an employee sign a form saying they reviewed it cover? So you should update an employee manual at least annually, at least get it reviewed annually, because the laws change pretty much annually and sometimes more often. And an employee signs an acknowledgement that says they've reviewed it, helps tremendously in the situation I just talked about. If somebody, you know, says, I didn't complain to HR because I was afraid or I didn't know how, and you can say, you had the handbook, you knew what you were supposed to do, you know, we have an anti-harassment policy. So it can help you to, as evidence that the employee knew their obligations. You know, it's not going to win your case just because you have a policy that's zero tolerance for harassment, doesn't mean harassment isn't going on and that you don't have to do anything about it. And then my company's small, I handle the HR functions. Yes, people wear a lot of hats. The best way for a non-HR person to stay on top of it, I would say, is to retain an HR consultant on an as-needed basis that can, you know, can keep you up to date with the laws. I mean, lawyers do that too. I'm always sending client bulletins and updates when there's new requirements that come up. But at least if you have an HR consultant that you can use from time to time, they can keep you up to date. Sometimes payrolls process, the payroll companies, sometimes they have their newsletters and things. So it's a good question. And you can't know everything. And if you're not a certified HR person, it could get you in trouble. Okay, next slide.
I think on that, Lori, there are also HR associations that they might want to join or talk to that sometimes have training programs for
Right, that's true.
HR
Yep.
and update type things. So
Right,
that's
that's
another another aspect. So as a follow on here, do companies have to have an HR department? Or because I was thinking some companies don't have anything at all. So how do you complain to the HR department if it doesn't exist?
You need to designate, I always say you need to designate at least 2 people at the company to whom complaints can be made. If it's just one person and the complaint is about that person, you may not feel comfortable going to them. So usually it's the CEO. I mean, you don't have to have an HR person, the CEO and a VP or any member of management, or, you know, you can designate the office manager and the CFO, but delegate at least 2 people to whom they can complain to. And you don't have to have an HR department or an HR person, but you have to have somebody that functions in that role, at least for these situations. So that's a good question. Okay. So sexual harassment, you know, this can be the subject of an entire webinar, and I do sexual harassment training for employers, and, you know, we delve deep. We're most familiar with sexual harassment in the workplace. The legal definition of sexual harassment is there on the slide. Again, a lot of legalese. It has to be unwelcome, and it's either there's two types basically. The first type is under 1 or 2 here, so it's unwelcome, and it's a request or verbal or physical act of a sexual nature when either submitting to that is a condition of somebody's employment, so saying yes or no, or, is a condition of staying employed, or an employment decision is based on whether that person accepted or rejected that advance. That's the more serious type of sexual harassment we call quid pro quo, which means this for that. Do this for me and I'll do that for you. The other type is under number 3. It's hostile environment sexual harassment. Like I mentioned earlier, it's conduct that is either severe or pervasive, meaning a pattern. And again, it has to interfere with your work performance and create what we call a hostile environment. So again, it has to be unwelcome. It has to be without consent. Sometimes it's consensual, but even conduct that starts out as consensual may become non-consensual, or there may be a line drawn where somebody says enough already, or this bothers me, stop, or I don't want to go out with you anymore, leave me alone. And then it's non-consensual anymore. It's important to know that workplace harassment is not limited to the office or the work site where the employee is assigned to perform duties. It could occur at a client's office, on a job site with clients, while somebody's at dinner or having drinks or traveling with clients, with colleagues, at the office holiday party, or even at home on your personal computer. It can be same-sex harassment. It can be an employee harassing his or her boss. And it is also, it's not male to female all the time. It could be a female harassing a male. It could also be harassment that's being perpetrated by a supervisor in a different area of the company. It could be a coworker, and it could be a non-employee, such as a customer or a homeowner or vendors, the mail person who comes in every day, or the UPS person. All of those, that type of harassment, an employer is required to protect the employees from. So not everything is considered unlawful sexual harassment. There's a lot of things that are unpleasant, unfair, but don't rise to the level of being severe or pervasive. So one incident, for example, of groping somebody's sexual body parts, that's enough. That's severe. But and massaging somebody's shoulders or touching somebody's arm or standing close, again, even if you don't intend it to be offensive, could be invading somebody's private space. People have different comfort levels and different cultures and backgrounds. So if there's a pattern of minor incidents, comments or questions or sending somebody cartoons, and it happens in a pattern, that could be unlawful harassment. So next slide, please. I know we're getting close to the end. It's important to have sexual harassment training for your employees annually. Every employer with 1 or more Illinois employee has to provide it for their employees. If you're a restaurant or a bar, there's special extra training required. You're not required to train independent contractors, but they're protected from sexual harassment. So I think it can't hurt to include them in training. Chicago now has, as of last summer, new requirements, not only for sexual harassment policies, which have to be in each employee's first language, but by June 30th of this year, there's now expanded training for employers with Chicago employees. It's 1 hour of sexual harassment training for non-supervisors, 2 hours for supervisors, and then everybody has to get another hour of bystander intervention training. So it's a lot of training. And I do need to mention the new federal Speak Out Act, which was signed in December, which makes it invalid to have a non-disclosure, confidentiality, or non-disparagement provision in a settlement agreement when it is related to sexual or assault or sexual harassment. Basically, people should be able to speak out about it. So next slide, please. So manager responsibilities. This is very important. managers are basically the agent of the company. That's the legal responsibility. And obviously managers shouldn't be engaging in discrimination or harassment or retaliation. And a harasser can be individually liable in Illinois. But even more than that, if somebody complains to a manager or a manager sees it happening or hears about it and doesn't relay that to top management or the boss or HR and just does nothing about it, the company could be liable, because once a manager knows, the company knows. And so you can't now use, well, the employee didn't complain to HR or she didn't follow the complaint procedure. If they tell a manager or a manager knows, that manager is making the company liable if they don't do anything about it, which includes, I'm just telling you this in confidence, don't do anything about it. I'm afraid of retaliation. I'll let you know if it gets worse. You have to tell that person, sorry, I can't keep it confidential. I have to relay this. That's the law. So it's important to, as I say, relay the complaints. Managers should take complaints seriously. And, everyone should take complaints seriously. Just because Harold is, 67 and he's used to pinching girls' butts doesn't make it okay. Things that might have been okay back then or for certain people, it's not okay. Hold everybody to the same standards from the top down. Make sure you're considering that it's the victim's perception, not what somebody intends, and don't assume it's welcome conduct. Okay, next slide. I want to give time for questions. Just, a quick employer HR to-do list. Some of this from last time and some of this from this time, but review and update contracts and your handbooks. Check your non-competes, make sure that they comply. Consider creative compensation packages. And on that note, I do want to say that I mentioned last week that as of November, employers in Illinois with 5 or more employees have to start offering retirement plans. It's never too early to do that. The Federal Secure 2.0 Act has incentives for businesses, tax credits. So check with your tax advisors. The tax credits are supposed to be golden, better than tax deductions. So there's the soapbox. Make sure you're complying with the salary band that we talked about last time. Prepare for this new Illinois paid leave that's going to be in force January 1st, and make sure you arrange for sexual harassment training. Okay, sorry for the fast talk at the end.
Thank you, Lori. Great stuff. And those were great questions, by the way. I want to go back to something you said at the top here as part of our key takeaways from what we talked about today. The whole notion of common sense. You covered a lot of legal and technical aspects that you're required to by law to follow. But I would say beyond that, and some of the things I talked about, your responsibilities as a leader or an owner of a business or a manager is to think about the common sense elements as well that may or may not be covered from a legal standpoint. And when I say common sense, I really refer to thinking about applying the golden rule. When you're dealing with employees and your organization and people in general, apply the golden rule and consider, is what I'm going to do here a decision I'm making, or what I'm not going to do, is it something that I would want done to me? If you follow that, I think it sets you up nicely. And Lori, I think you're nodding in agreement that if you set yourself up and practice the golden rule, it's going to put you on a good course to not run afoul of a lot of legal technical stuff too. So I just wanted to reinforce that. Just to do some quick takeaways here, and then we'll entertain some questions to wrap up. It's important, as I mentioned, to evaluate manager and supervisor behavior and actions and understand that they have an impact on culture, to pay attention to how employees act, feel, process, and connect. All those things influence culture. To promote a workplace culture of zero tolerance for discrimination and harassment. I think Lori made that very clear. There's no exception. If it's discriminatory harassment, it is just that. Understand disability law obligations to candidates and reasonable accommodations to all employees. To educate managers on the duty to report complaints. And that was a really good point you made. Lori, where if an employee is concerned about not getting someone in trouble, but they surfaced it, the manager doesn't have a choice. They have to report it. And lastly, to provide that annual sexual harassment training, which is a requirement, I believe, for every employer in the state of Illinois. Is that right, Lori?
Yes,
Regardless of size, correct?
right. The expanded is for Chicago only, but everybody has to do the 1 hour in
Yeah.
Illinois.
Right.
Otherwise.
So very important. So with that, those are some key takeaways from the day. We want to entertain some questions here if you have any more. While they do that, I'm going to show, as I promised up front, there's some free resources we're offering to you to give you an opportunity to take a picture of this QR code. If you take a picture of that QR code, you'll go to a spot where we've got some resources, a manager's checklist of 10 winning ways to engage employees, a values, mission, and vision blueprint, which you can use to build values, missions, and vision from scratch for a business that you're starting up, for instance, or to use that blueprint to validate or to evaluate your existing set of values, mission, and vision. And then also a legal workplace culture and compliance checklist that Lori put together. So we invite you to take advantage of these. If you're not into doing QR codes, we're going to show you our contact information next year. And to wrap up, if there aren't any questions, and I'll turn it back to John, we are offering a couple of complimentary assessments or audits for you. And these are no charge, no obligation. Lori is perfectly happy to do what she calls an employee compliance audit. And there's her contact information. You can call her or email her. And on my side, if you also would like to take advantage of an assessment where I will do a sort of a look under the hood, we'll spend 1 hour on the phone or on Zoom, and I'm going to ask some questions and I'm going to assess and give you a sense of the level of employee engagement in your organization and some ideas on what you can do about that. And also take a look at your culture and some things you can do there to impact and get to a culture more of choice as opposed to by chance. So that's my contact information, phone number. And with that, John, do we have any other questions?
I've got just one here, Mark, and it was on the, is it FMLA, the leave, family leave? Does that need to be taken consecutively or can it be taken in multiple sections?
That's a great question. It can be what we call intermittent leave. So it's 12 weeks over a 1-year period, basically. So other than for the child bonding leave has to be more immediate, but otherwise it could be, 1 day a week for dialysis or, half days or when I need it. And, then there's some difficulties with certain types of conditions that you can't always predict. You don't know when someone's going to have a migraine or some kind of episode, and it makes it difficult to, to perform a job. But you have to try and accommodate that to the extent you can, unless it gets, too difficult, and that's another story.
So the other question I've got here is there a recommended way to handle requests for disability accommodations? Is there specific forms to fill out, or how does that happen?
That's important because sometimes, you might hear from an employee or feel that they may be needing accommodations, but they haven't exactly asked for them, and you have to be careful not to invade privacy and speculate that somebody might have a disability. So an employee doesn't have to specifically request or use special words. They don't have to say, I have a disability, I need an accommodation. If they bring in a doctor's note with restrictions, the person, just had surgery and they can't lift for a few weeks, or somebody says, I might need some time off, or I might need a flexible schedule for this or that, then that clues the employer in that, okay, this is somebody that may be asking for an accommodation. So what you do is, I have a medical certification form that the employer gives to the employee. And you basically say, if you're requesting, or if you think you might need accommodations, here's a form, have your doctor fill it out. And it tells us, because neither the employer nor the employee can really make that assessment, what's the condition? What does the doctor think that you need? And then the employee and employer have to discuss it and determine whether those accommodations could be made, what might work. You don't have to give those specific ones, but you have to have some interactive communication to try and solve it and see if there's something that could be given so that the employee can do the job. So just know that you don't have to wait for a special form or special, questions from the employee.
So in terms of a doctor's note, does that have to be, does that have to be on doctor's letterhead? Is there any validation? Because, I've had instances where it sort of seems like the person's brother-in-law is pretending to be a doctor. So is there some way to validate that?
Well, it's difficult. So even if you get a doctor's note, you can have them fill out your certification form and sign it. And hopefully, again, it's not, somebody's brother-in-law that's
Okay.
just, and they have to give their credentials, which you can look up. With FMLA, if you don't believe one doctor's opinion, then the employer can pay to get a second opinion. And if it differs from the first one, then the employer can pay to get a third opinion. You can't do that unless it's under FMLA. So you basically have to take the doctor's word for it.
Okay, but they do have to give credentials like their, whatever their number is.
Right, exactly. Yeah.
Yeah. Okay. Well, Mark and Lori, thanks a lot for the presentation here. There's been a lot of really good information.
Happy to do it.
And just as a reminder, we've got a couple of webinars coming up: Understanding Small Business Financial Reporting on April 27th, and then How to Transition a Good Idea into a Great Business on May 2nd. And please visit our website, www.score.org/North Chicago, for additional information and to engage a free confidential mentoring session here with one of our 70 mentors. And I think that's the end of the slide presentation, right, Mark?
Yes, it is. Just one other point too is that, John, I believe this session will be recorded and available on your website
Yes.
as well. So that'll be up in a couple of days. So if you wanted to go back and review this again, and in case you missed anything, you're welcome to do that there. And again, as well as contact either Lori or I. We're happy to answer questions on a one-on-one basis.
Yep.
So we're available to do that. And we, again, John, we appreciate you and SCORE for having us here. We're very honored to have done what we did today and last week.
Yeah, thank you very much. And just to
thank you all for your
clarify,
engagement.
it's available on our YouTube channel. So there's a link on our website to our YouTube channel. So all of this stuff goes on there, and it should be available in a few days here. But thanks a lot for both of you. Been a lot of really good information here for employers and employees as well. So we really appreciate it.
Thank
See you
you.
later.
Best wishes to everybody.
Thank
Take
you,
care.
everybody. Have a good evening.
Yeah, take care.
Bye-bye.